Well, as you're all aware, it has been a day of nerve-wracking arguments by senior councils and councils representing the two sides of Nairobi Governor Mike Mbuvi Sonko as well as the County Assembly. The Senate has reconvened. We want to hear from our reporter who is on the ground, Gladys Mungai. She's been tracking the happenings there. Gladys, it's good to see you. Bring us to speed with the latest. Gladys, can you see me? Can you hear me? Bring us to speed with the latest.
Coming to you live from the Senate of Kenya. This is the second day and the last day of the hearing into the investigation of the impeachment of the Nairobi Governor Mike Sonko. This is a sitting that has started since 9 a.m. in the morning, where the senators sought to hear from the legal team of the Governor Mike Sonko in regards to the charges that have been leveled against the governor. You remember that on December 3rd, 88 members of the County Assembly of Nairobi voted to impeach the governor, and that necessitated the sitting of the Senate, which has been hearing this matter in plenary. And yesterday we got to hear from the members of the County Assembly through their legal team that was led by lawyer Njiru Ndegwa, and today they're still seeking to have their status quo remain. And we also had to hear from the Senate, the legal team representing the governor for Nairobi County, which is mainly today was their day to get to quash the status quo of the impeachment of the governor. And the governor was put to task to explain, among other charges, the travel of his daughter to a foreign country. Members of the County Assembly claiming that the county government indeed did pay for that trip. There has been a bone of contention in regards to the amount of monies that are said to have been used during that trip, staggering to about millions of shillings. But the governor told the Senate that the amount in question is just 2.6 million shillings, and indeed that the county government didn't pay for that trip per se, but the county government did indeed pay for matters to do with air travel. There are a lot of grounds under which the senators will be voting upon, and among them is abuse of office, as well as gross violation of the Constitution of Kenya and gross misconduct, and also matters to do with national laws. And under any
December 2020, the Nairobi City County Assembly approved a motion for the removal from office by impeachment of the Honorable Mike Mbuvi Sonko, Governor of Nairobi City County. And further, whereas by letter reference number NCCA SPK 12/12/2021, dated Friday 4th December 2020, and received in the office of Speaker of the Senate on Friday 4th December 2020, the Speaker of the County Assembly of Nairobi City informed the Speaker of the Senate of the approval of the motion by County Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas, pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012, Standing Order number 75 of the Senate heard the County Assembly on grounds of removal from office by impeachment of the governor. And further, whereas, pursuant to Article 181 of the Constitution, Section 33 of the County Government Act 2012 and Standing Order number 75, the Senate also had the governor of the Nairobi City County on the grounds of removal from office by impeachment of the governor. Now, therefore, pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012 and Standing Order number 75, the Senate resolves to remove from office by impeachment the Honorable Mike Mbuvi Sonko, the Governor of Nairobi City County, on the following charges. 1. Gross violation of the Constitution or any other law. 2. Abuse of office. 3. Gross misconduct. And 4. Crimes under national law. Thank you, Mr.
Second. Next order. Order number 4, motion, proposed removal from office by impeachment of the governor of Nairobi City County.
Leader of majority.
Mr. Speaker, sir, I beg to move the following motion. That whereas pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012, on Wednesday, 3rd December 2020, the Nairobi City County Assembly approved a motion for the removal from office by impeachment of the Honorable Mike Sonko, Government of Nairobi City County. And further whereas by letter, reference number NCCA/SPK/12/2021, dated Friday, 4th December 2020, and received in the office of the Speaker of the Senate on Friday, 4th December 2020. The Speaker of the County Assembly of Nairobi City informed the Speaker of the Senate of the approval of the motion by a County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012, and Standing Order 75 of the Senate had the County Assembly on the grounds of removal from office of the by impeachment of the governor. And further, whereas pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012, and Standing Order number 75, the Senate also heard the governor for Nairobi City County on grounds of removal from office by impeachment of the governor. Now, therefore, pursuant to Article 181 of the Constitution, Section 33 of the County Governments Act 2012, and Standing Order number 75, the Senate resolves to remove from office by impeachment the Honorable Mike Sonko, the Governor of Nairobi City County, on the following charges. 1, gross violation of the Constitution or any other law. 2, abuse of office. 3, gross misconduct. And 4, crimes under national law. Mr. Speaker, the matters here are straightforward. It is a constitutional duty of this Senate to take up this matter. We shall neither shy from it nor be intimidated. We must move in this direction and make decisions. Mr. Speaker, we have heard evidences the last 2 days. We have listened. In your own words, Mr. Speaker, you called it some boring session. It will be boring, but we heard. And I want to thank, Mr. Speaker, members, all the senators. The numbers proved to you, Mr. Speaker, that senators paid keen attention to the presentations on both sides. And everybody has been given a chance to be heard. And so, Mr. Speaker, this is a time of reckoning. And I'd like to ask members, you have heard, you made a decision, and now the time has come to put it to a vote. And I want to encourage members, please, this is your duty, and you must act. I want to thank everybody and thank the chairman, the Speaker, for the way that you conducted this business. Mr. Speaker, I think we may have to reconsider certain things about how we run this business, but here is a time that will come. I will not take long, Mr. Speaker. I'm going to move and ask the leader of the minority to second. I beg to move. Thank you, Mr. Speaker.
Mr. Speaker, I'd ask that order be kept while we are having the proceedings. As you know, there are senators upstanding.
Honestly, take your seat, sir.
And that is not allowed at all. Mr. Speaker, strictly speaking, I have 1 hour to second the motion. But being cognizant of the importance of this motion, I beg to second. And Mr. Speaker, I want just to make the following remarks. The question of removal is not a question that can be made by any one single senator, but on account of the aggregate vote of all the senators as an expression of the resolution of the Senate. Mr. Speaker, I want to place before you certain matters which are in the Constitution to draw a contradistinction. And if the Attorney General Emeritus and the judge...
Order, Senators. Emeritus. Please.
And the judge...
Let's make it easy for him to second them.
The judge is on his feet, and he's supposed to be judge. Yeah, I don't know how he's going to judge. Now, Mr. Speaker, this is probably the only power under the Constitution that has remained intact throughout our constitutional dispensation. Is a power which is so onerous that, Mr. Speaker, I believe that any time we are faced with an impeachment, we should give the whole country the feeling that anybody who appears before the Senate is assured not only of justice being rendered, but even in terms of our conduct, justice will not only be done, but would be manifestly be seen to be done. And that goes not just from what we say as a Senate, collectively as individually, but even as the way we conduct ourselves during such proceedings. And Mr. Speaker, I just wanted to, for the purposes of seconding this motion, draw to the attention of the Senate two issues. One, the principles of how impeachment is to be carried out and the standard of proof that is required in an impeachment is now a matter which has been well settled by the courts in the various decisions that have been made here. And I would plead to the Senate also to be consistent. There was a time, Mr. Speaker, when I tried to urge the Senate that is very important under the principle of legality and committee of institutions, that we should respect what the courts do in as much as what we want the courts to do. I think there's a matter which is still a matter of debate. We seem to be shifting goalposts. In other matters that I remember in the Samboja case, people were saying we should never be compelled to obey court orders. And in these particular proceedings, we are being urged that this matter is before the court and therefore we should not be in a position to deal with it. But having said that, I want the Senate to look at Article 99 of the Constitution in relation to disqualification of members. When you are charged in a criminal court and you are convicted, you cannot be removed as a member of this House, because the Constitution says that, and this is Article 99, sub-article 2H, that you must have been found in accordance with any law to have misused or abused a state office or public office, or in any way to have contravened Chapter 6 of the Constitution. That is why it is possible for a member of Parliament who has been convicted of an offense can continue to be a member of the House until the appeal process is exhausted. And I think we have examples in the county, in the National Assembly. But when it comes to the removal of a county governor, the words there are very different in contradistinction to what is contained in Article 99. And Mr. Speaker, it says the following, and I read Article 181 sub Article 1. A county governor may be removed from office on any of the following grounds. It does not say to have been found. It says on any of the following grounds. Then when you go to Article 1B, it says where there are serious reasons to believe, not to have been found. There are reasons to believe. And those people who have read the American Constitution and the impeachment processes in the United States of America, and a lot of jurisprudence on this, they are saying this was the instrumentality of Parliament to control those who would act in abuse of power, that if they waited for court processes, that undermining of the authority of delegated authority from the sovereign authority, which is the people, would have to wait until the 5 years or 4 years of tenure is over. So, Mr. Speaker, what am I trying to say? What I'm trying to say is the standard of proof is very different, and as the courts have borne out in the many appeals that we have been referred to. But the finding as to whether there has been a violation of the impugned conduct as stated in the Article 181 of the Constitution is really a political question. But we have to have a threshold because they are set out in the Constitution. But in my view, it's still a political question. It's a political question. So at the end of the day, Mr. Speaker, all that I want to say in conclusion is that this is a very important instrument that is donated only to this House. And my fear is, Mr. Speaker, and we must revise these rules. We must look at the Act again. My belief is that so far we have not given the solemnity to this process, because imagine the next time probably is the President of the Republic of Kenya that we are impeaching, contrary to the mandate they are given to the people by the people of Kenya. Everybody in the world will be watching us. It may be the governor now, but if it was the President of the Republic of Kenya, the whole country will be watching. And Mr. Speaker, therefore, I believe that we must revise the rules. We must amend the County Governments Act in relation to the impeachment. And I want to persuade the House that a committee process probably is better. In the United States of America, they did not have a provision for the committee system. What they have in the law is actually plenary, but they have found out over time that plenary doesn't really work. It doesn't do justice to the grounds and the seriousness of the grounds which normally those who have been impeached face. So, Mr. Speaker, with those remarks, I beg to second. Thank you.
Honorable Senators, I now propose the question, which is that whereas pursuant to Article 181 of the Constitution and Section 33 of the County Government Act 2012, on Wednesday, 3rd December 2020, the Nairobi City County Assembly approved a motion for the removal from office by impeachment of the Honorable Mike Mbuvi Sonko, Governor of Nairobi City County. And further, whereas by letter reference number NCCA/SPK/12/2021, dated Friday, 4th December 2020, and received in the office of the Speaker of the Senate on Friday, 4th December 2020, the Speaker of the County Assembly of Nairobi City informed the Speaker of the Senate of the approval of the motion by the County Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Article 181 of the Constitution, Section 33 of the County Government Act 2012 and Standing Order 75 of the Senate had the County Assembly on the grounds of removal from office by impeachment of the Governor. And further, whereas pursuant to Article 181 of the Constitution, Section 33 of the County Government Act 2012 and Standing Order number 75, the Senate also had the Governor for Nairobi City County on the grounds of removal from office by impeachment of the Governor. Now, therefore, pursuant to Article 181 of the Constitution, Section 333 of the County Government Act 2012 and Standing Order 75, the Senate resolves to remove from office by impeachment the Honorable Mike Mbuvi Sonko, the Governor of Nairobi City County, on the following grounds. Charges: 1, gross violation of the Constitution or any other law. 2, abuse of office. 3, gross misconduct. And 4, crimes under national law. What's your point of order? Who is it? Okay, Senator Sakaja. Yeah, I've finished. What's your point of order?
Mr. Speaker, sir, I stand under Standing Order 106 on limitation of debate, which clearly says that the Senate may, on a motion made by any senator in accordance with the standing order, impose a limit in respect of debate or any particular motion or bill by allocating a limited period of time for such debate or by limiting the time during which senators may speak in such debate or by imposing such limitations. Mr. Speaker, Standing Order number 106(2) clearly says that such a motion may be moved without notice. I beg to move this motion, Mr. Speaker, that this debate be limited to 3 minutes per speaker, Mr. Speaker, so that, Mr. Speaker, we save time. Mr. Speaker, I want to call upon Senator George Khaniri to second this motion. Thank you.
So we have to speak on this motion. Seconded. Therefore, I'll just give 3 minutes. Senator Sakaja.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, I'd like to...
Senator Kindiki Kidure.
I'm not the Speaker.
Yes.
I have to call.
Give him the mic. No one is giving him the mic. Mr. Speaker, sir.
Okay, yeah.
The Senator for Kakamega County has moved a procedural motion, and properly so, which has been seconded by the Senator for Vihiga County. However, Mr. Speaker, sir, with tremendous humility, I believe that the Speaker of the House must take a vote, a viva voce vote, to ascertain whether that motion has been passed before we can progress. Because I am of the opinion, Mr. Speaker, that talking about removing our governor is not a small matter. As many senators as possible should be able to speak for at least 5 minutes, to at least to say something. Minimum 3 minutes. By the time one rises up, time will be over. So, Mr. Speaker, I'm begging. But if it is the opinion that we do 3 minutes by majority, I'll abide by the decision of the House.
Okay. A motion has been proposed to limit the time of the motion and seconded. Now I propose the question, which is that the time for this motion be limited to 3 minutes. As many are of that opinion, say aye. Aye. As many are of contrary view, say nay. The ayes have it. Senator Sakaja.
Mr. Speaker, I seek your indulgence, Mr. Speaker. I know members want us to dispense with this matter quickly, but as a senator representing Nairobi, I would kindly ask that I beg your indulgence that I speak for 5, or 6, Mr. Speaker, kindly.
Okay, 5.
Thank you. Senator Ridama is saying 10. I don't need 10. Mr. Speaker, as I speak to this motion, Mr. Speaker, kindly advise senators not to address me, to address you. You're asking a point of order to the Speaker, not to me. And unless you're given, I keep speaking. Mr. Speaker, In speaking to this motion...
What's your point of order, Senator Murkomen?
Mr. Speaker, there is a tradition which has been established in this House. First of all, Mr. Speaker, I know I cannot raise a point of order against you, but you only proposed the question, you didn't put the question on the time we are supposed to debate here. So just that's out of procedure, but that's water under the bridge. The real tradition that has been established in this House from the time impeachment started is that the senator of the county where the governor is from speaks last, Mr. Speaker. And it's a tradition that has been established because he speaks last, and generally there's always an indulgence to give him more time. And there's a reason why he should speak last, is so that then he can sum up everything, Mr. Speaker. And you know, generally there was a tradition. So I want to beg my friend Senator Johnson Sakaja, if he can wait for the other members to contribute first, so that then we can follow.
Okay, Senator Sakaja, is that okay?
Mr. Speaker, I acknowledge tradition. These are House of Rules and tradition. I have much to say. I will abide and speak last, but I hope that what I wanted to say will not be clouded by what members say. But I urge that even if I speak last, you still give me an extension of time when I speak, Mr. Speaker.
Okay, Senator Isaac Mwaura.
Sorry, Mr. Speaker, you caught me off guard. I still thought I wanted to listen to Senator Sakaja. But I want to really say that this whole process of impeachment is a far much better, improved version than the way in which we impeached the governor for Kiambu, Ferdinand Waitito. I think I saw a lot of civility from the senators and also the cross-examination from the council. And that is something very commendable, Mr. Speaker. But I also want to say that we really need an impeachment procedure law so that we are very clear that it is not whimsically possible to just make a determination as to whether we really have a case for a plenary or for the committee based on maybe what may have happened by a certain committee or certain persuasions of the moment. But Mr. Speaker, having said that, it is my opinion that indeed, yes, the governor has a case to answer. I think I was moved personally by the charges against him, especially around gross misconduct, issues to do with variation of tenders, and this topic I keep on talking about called development corruption, where you use development money meant to help the poor Kenyans, you divert them by compromising on the standards of that project so that then those monies end up in people's pockets. It was clearly demonstrated to us by the County Assembly that a lot of monies were actually diverted from a stadium project, and further, quite poignantly and sad, that monies meant for bursaries have actually been diverted to pay lawyers. And you know, this is a very clear conduit for self-enrichment of legal fees that would not otherwise be quantifiable. I don't know, Mr. Speaker, whether it is the amount of English, and today we've had a lot of it, that then would amount to in the hundreds of million shillings that have been diverted. And Mr. Speaker, now that I can see the yellow line, I want to say that really we owe it to this country to have governors having the highest threshold of decorum. We want people who, when they look at their TVs, at our TVs, they will see that these are honorable people who have been elected to office to serve. And in my opinion, Governor Mike Mbuvi Sonko has not presented himself in such a manner. I think he's a very good example of someone who, in my opinion, who should not have even been elected to the office of the governor of Nairobi. And I so ask that this honorable House do make its considered opinion so that we...
Senator Olekino.
Thank you, Mr. Speaker. Mr. Speaker, I rise to oppose this motion with the following reasons. Mr. Speaker, I've sat here for the last 2 days, listened very carefully to the allegations by the County Assembly, and in my view, which I wish to convince my colleague within 3 minutes, those allegations have not been substantiated. Mr. Speaker, sir, we were told that money was diverted, bursary money was diverted to pay for lawyers, to pay for other services. But the evidence which was presented by the county governor spoke differently. Mr. Speaker, we were given documents from Central Bank that showed that that was stopped. Mr. Speaker, sir, what happens? Normally, when you're processing a payment, it leaves IFMIS and it goes to IB. At the end of a financial year, if that money has not cleared from IB or internet banking, it goes back into the county revenue fund. Mr. Speaker, sir, with my 2 minutes left, the issues that we have been entertained here with revolve around 3 particular issues. One, Article number 187, 2A and B. And this is a matter that this House must sit seriously and consider. Because when it says that arrangements shall be made to fund transferred services, it does not say the national government should put together a legal framework to transfer those services. This is a threat to devolution, and we must be alive to that. The second issue, Mr. Speaker, has got to do with the relationship of the Treasury, the County Assembly, the County Executive, and this new entity called NMS. Mr. Speaker, sir, we will be violating Article 219 if we agree with the County Assembly that, yes, NMS should get money directly from the Exchequer. Mr. Speaker, sir, I have 50 seconds. I want to beseech you, my brothers and sisters. This is a very tough time for devolution. If we agree to violate Article 187, 2A and B, and Article 219 of the Constitution, we will be doing us a disservice. In the last few seconds, Mr. Speaker, sir, I'd like to end with a quote from the Bible, Proverbs 12:22. It says, "Lying lips are an abomination to the Lord, but those who deal truthfully are his delight." I wish to beseech you to deal fruitfully and truthfully. I thank you, Mr. Speaker.
Senator Cheriot. It's not there. Senator Langat Christopher.
Thank you, Mr. Speaker, for giving me this chance also to say something. I want to oppose this particular motion deeply. One is because of procedure. The fact that if we are not careful as the House, I want to say that the irregularities that are happening in the county assemblies are likely to translate to this particular House, Mr. Speaker, sir. And I want to say it was not very clear up to this particular time if the threshold was made clearly in the county assemblies. And I want to say that unless we are careful, sooner or later, this particular House will be converted by the MCAs as a lynching ground to the governors. Governors are now under fear. They fear a lot. They fear the MCAs, and they fear that they will be brought here to be lynched. So we need to protect devolution by actually, we may not actually, we may not be having substance on what actually the governor gave, but the procedure is faulty. You could see, and everybody even here, is not, it is not clear to all of us if those particular MCAs who are in Mombasa, if they actually voted, Mr. Speaker. So I want to say that the faulty process produces faulty results. And I want to say we must be careful on the procedures that are taking place in the county assembly, or we risk this House becoming a lynching ground for the MCAs actually who have got a lot of demands that are putting on the governors that are not realistic, and they cannot be actually accepted. So I want to beseech this House that if only we could send this particular case back to the MCAs so that the procedure be followed effectively, Mr. Speaker, we have got no problem with the results. But a faulty process also leads to a faulty results at the end of it. So I beg this particular House that we reconsider this matter with seriousness that it deserves as a way of protecting devolution. Thank you, Mr. Speaker.
Senator Mogeni Eric Okongo.
Thank you very much, Mr. Speaker. Mr. Speaker, this is the fourth impeachment we are doing in less than 3 years as senators. And I think for those who have served more than one term, there would even be more. Mr. Speaker, we are sitting as a jury, it's a judicial proceeding, as a court of law. It's important, Mr. Speaker, that in the eyes of anybody who comes before us, to see that not only has he or she been subjected to a process that is fair, but that he has also received justice. Mr. Speaker, the way we conduct these proceedings need to be reviewed going forward. Mr. Speaker, if you go to the United States of America, an impeachment of a president is done under a serious investigation. I remember that during the impeachment of Richard Nixon, Hillary Clinton was one of the attorneys that were assisting with gathering evidence against the then sitting president. But as we speak here today, Mr. Speaker, you have seen that there are many instances where we are not able to get proper assistance from advocates who appear for the respective parties. We asked issues touching on whether orders were served. We were trying to get proper records from the assembly. We were told we ought to have summoned the clerk to appear before us to give us further evidence. Mr. Speaker, we really must put in place a body that should review the way we conduct this inquiry so that parties and Kenyans in general can have confidence. Mr. Speaker, this is like when you face an election petition. When you have received the mandate of the people to be their leader and you are taken to an election petition court, you expect fairness and you expect justice, and the verdict that is passed against you should be one that enjoys the confidence of the people that voted for you. But in conclusion, Mr. Speaker, our governors must also know going forward that if you violate our constitution or if you violate